All right. Good afternoon, everybody. First off, let's get started with the important stuff. First, a riddle. What do you have when you have three lawyers buried up to their necks in cement? Obvious answer: not enough cement. Now, there was a recent study that came up from the National Institutes of Health. They announced that they're no longer going to use rats for medical experimentation. In their place, they're going to start using lawyers. Now, they've given three reasons for that. Number one, there are apparently more lawyers than there are rats. Number two, the medical researchers don't become emotionally attached to the attorneys as they did to the rats. And number three, no matter how hard you try, there are just certain things that rats won't do. All right, enough of that. Let's talk about a negotiation and settlement, part one. We will be following up with part two next month. Let's see if you remember this one. If you do, you're old. You got to know when to hold them, know when to fold them, know when to walk away, know when to run. If you know who that is, Kenny Rogers, you are at least as old as me, and that's a sad, sad thing. So how early is it? Is too early to discuss settlement? Well, 99+% of the time, it's never too early. Less than 1% of the time, I'd say there's absolutely no point in going into settlement discussions early or even at all. When is that? Well, if you're fighting a policy battle, if you're out to if you have, for example, a client who demands a zero settlement authority. I've had clients, an NGO, for example, for whom I had zero authority. I literally was not allowed to settle for a penny. So settlement discussions were not only could not only be too early, they were just non-existent. What if you're fighting a political battle or trying to make case law? Well, obviously at that point it may be too early to discuss settlement as well, or you're simply drawing a line in the sand. Let's say you have a plant closure with 300 people being laid off, large union layoff, and you've just received the first application for adjudication. Probably don't want to send the message to the other 299 potential applicants that were a soft touch for easy money. In fact, probably want to make an example of this first at least a dozen or two applicants to let the rest of them know that we are not a soft touch. So when should you start thinking about it? Do we need to think about it when they're PNS or MMI for all body parts? When the claim is denied? Well, no, as I suggested earlier, consider settlement at every stage. You don't want to miss any of opportunities, and they can come up from the very beginning. Some of the hurdles to settlement may be the injured worker, pulling the impossible hopes out, applicant's counsel, the WCAB, the judge, the information assistance officer, et cetera, et cetera. One of my partners, Greg Fletcher, says a compromise and release is less about the numbers and more about who wants it. And I think that's absolutely true. Obviously, you can't force to settle by a CNR. You always have to have the agreement by the parties. And the question is value of the case, and negotiations, which simply are an art. And this slide actually says it's outside of the scope of the seminar. Case valuations is, but negotiations is not, and we're going to talk about that. So back to the too early to discuss. Nope, not 99% of the time. Again, consider it every step of the way. Does the applicant need money fast? Are they facing, for example, a third strike? I once had a case in which there was a fairly severe injury. My client obtained some subrosa, easy for me to say, sent it to me. I asked, what is that? They said, take a look at it and you see what you think it is. I took a look at it and I concluded, hey, this looks like this guy is fencing stolen property. My adjuster said, that's exactly right. I think so too. Shortly thereafter, we got notification that, guess what? The guy had been picked up for fencing stolen property, which was going to be a third strike felony. Having learned that, we also learned that he needed an expert witness. He needed money fast, and we were able to settle this case economically and expeditiously. Does applicants' counsel need money fast? We have no idea whether they're pressed to pay the payroll in 2 weeks or pay the rent at the end of the month. Obviously, another point that we can use to push for settlement. They're never going to tell us, but you just never know. And thus it can't hurt to try to explore these things. Consider again every step of the way. First contact with applicant's counsel, at the deposition, during correspondence, just before the medical legal examination, just after the medical legal examination. We're going to go over these in detail. Pre-trial conference, MSC, trial before, during, and after, absolutely. And also don't forget to check your calendar. I'm sure most of you have followed this, but the holidays are coming, and injured workers need money to buy presents for the kids and the family. Obviously, some quick, fast money for them is highly attractive, particularly this time of year or when the kids are having a birthday, et cetera, et cetera. Vacation time. First contact with applicants counsel. It gives you an opportunity to sort of feel them out and try to solicit a demand. Ask what they think this case is really worth. If they're in the right ballpark, settlement negotiations can be begun in earnest. It also gives you an opportunity to find out what the applicant's attorney really thinks of the applicant. In most cases, they'll hide their disdain for an applicant whom they hold in disregard. But sometimes the applicant is so repugnant that they'll slip and let out that they're not the biggest fan of this applicant. I've had that happen many a times. In fact, recall a death case in which the applicant had a low back injury, seemed to be getting better and better and better. The next thing you knew, he had committed suicide. The grieving widow brought a death claim saying that he obviously killed himself because of the pain in the low back. So came to learn, however, that the night before he killed himself, he had learned that she was up the street at the no-tell motel with her new boyfriend. Obviously, applicant's counsel sort of let on that he wasn't a big fan of her, and we were able to get a very expeditious, very economical settlement, far less than any discovery would have cost. So this provides you the initial valuation parameters to, among other things, get authority, determine the extent of discovery. If they really want a nuisance value, you don't want to be spending lots and lots of money on depositions, subpoenaing records, and sub rosa, et cetera. What about at the deposition? Well, even before the deposition begins, applicant and applicant's counsel may be very nervous about what it is that you might learn, what kind of secrets they have, what kind of skeletons are in their closet. Oftentimes, if we're able to engage in settlement negotiations before or during the deposition, the most important thing to applicant's counsel is going to be, well, they can't say this, the most important thing is going to be getting their attorney's fees, because oftentimes this is the most valuable part of the case for them. So I tend to be very, very generous and recommend that you do so the same. That you do the same when settlement is in the offing at deposition, so that we can tell applicant's counsel, okay, we'll get you the 2 or 3 hours of deposition fees, giving you all the more, even though the deposition hasn't proceeded, giving you all the more incentive to resolve this case and get the biggest buck for their bang, or biggest bang for their buck. During the deposition, you might find, the applicant might find that this deposition is going longer than they expected. They expected to be in and out in an hour, hour and a half, and perhaps it's dragging on. It might be dragging on intentionally by defense to make sure that applicant in the right case is squirming. It may be far more detailed. I didn't expect the defense attorney to ask this, that, or the other thing as they keep thinking the applicant. It may be more embarrassing, particularly in side claims, than applicant had expected. And although in workers' compensation we tend not to be very adversarial, there are times when being adversarial is called for, and that may rattle things a little bit and get applicant more inclined to consider a settlement offer. And finally, as the deposition is progressing and the applicant's not really sure whether the deposition is going to turn left, turn right, or go straight or go backwards, they may be begin to be worried that we're going to discover more leads that they prefer that we don't know about. In short, somebody may cry uncle at the deposition. I've got a fun procedure, speaking of depositions, with handling psych depositions. And now I should say this is a mean approach, and it does not apply to the 2 or 3 or 4% of the psych claims that I think are absolutely legitimate. But you know the kinds of claims that I'm talking about, the skin and contents, and oh yeah, my employer gave me a bad look, so now I'm psychologically deranged. Normally in that deposition situation, take the normal orthopedic or a regular body part deposition for the hour and a half, 2 hours, whatever it takes. And I'm the nicest guy in the world. I'm the Eagle Scout that I am. But then at the conclusion of that 1 or 2.5 hours, I ask applicants counsel, can we take a brief break outside of the earshot of your client? And we move to applicant counsel's office, and they say, listen, what is this psych component? Is this your client just wants a few happy pills or a few sessions of talk therapy or what have you? Because if that's what they want, my adjuster is the nicest person in the world, and I'm sure they will authorize this, regardless of what URIMR says. And of course, this is code for I've already got this authority. Indicate to applicant's counsel if I'm more than willing to stipulate to this treatment on the record if they're willing to dismiss the site component for all other purposes. I would say that 85% of the time this works. Now, Tammy, when she was introducing me, mentioned that I've been practicing in northern, southern, and central California in terms of workers' compensation. This approach has worked throughout the state of California. And here's why I think it does. First off, applicant's counsel doesn't want to sit through 2, 3, 4, or 5 hours of a crying applicant and mean, nasty questions. Number two, in all likelihood, the case value in terms of the psyche holds very little value. The real battle is going to be treatment from applicant's counsel's perspective, and they really don't want to get in that fight because it's not going to make them any money. Third, applicant's counsel gets to look like a hero. Applicant's counsel, after we put the stipulation on the record that the applicant is getting the treatment and that we're dismissing the site component for all other practical purposes, applicant's counsel can say to their client outside of earshot from defense counsel, hey, remember I told you Barthel was going to ask you all those mean, nasty questions? Well, I've made it so that he can't ask you these mean, nasty questions, and he never will. And you know how you wanted that treatment? Well, I've got you that treatment. So applicant's counsel can look like a hero. The defense can save a whole lot of money in discovery and in terms of the site component, and everybody's a little bit happier. Another war story. Actually, that was the war story. I find after doing anything for 25 years, suddenly I'm old enough to have a war story for virtually everything you talk about. You know you're getting older when. All right, regular correspondence, phone calls, letters, emails, text, obviously. And sometimes you get the impression that applicant's counsel simply is not relaying the settlement offer. In fact, you may be quite certain of that. Well, that is not appropriate. In fact, it's in violation of the rules of professional conduct. Rule 3-510 says a member, that is an attorney, member of the Bar Association, shall promptly communicate to the member's client all amounts, terms, and conditions of any written offer of settlement made to the client in all matters, underscoring all the more that fact that we should be making these offers in writing. So what does that mean? Well, if you've made any significant settlement or a significant change in your settlement offer, applicant's counsel simply has to relay this. So this provides you numerous opportunities to dangle that settlement lure in front of the applicant and applicant's counsel. And if you're concerned that applicant's counsel simply is not relaying these offers, remind applicant's counsel in writing of Rule 3-510. I suspect there are a number of attorneys who simply do not know about this rule, and a little reminder that does a couple of things. First off, it tells them that what they need to do, and two, it suggests that you may actually know the law a little better than they, and perhaps they should play ball with you and be reasonable. What other steps? Just before the medical legal and just after the medical legal, before the report has even issued. Thank you, AMA guides. What do I mean by that? Well, for those of you who've been doing workers' compensation for way too long, and you remember the 1997 permanent disability rating schedule, estimating permanent disability, guessing at permanent disability before the medical legal was virtually impossible. Anyway, it was impossible to do with any level of accuracy. That's no longer true with the AMA guides, unless they're going to Alvarez Guzman you, which doesn't sound like a pleasant experience. Unless they're going to Alvarez Guzman you, you can pretty much tell using the AMA guides what the level of impairment and ergo the level of permanent disability will be. So we don't need the issuance of a medical legal. So just prior to or after the medical legal appointment, there's no reason we shouldn't be exploring settlement at that point as well. Pretrial conference, MSC. and trial, before, during, and even after, yes. Why? Well, the PTC, MSE, and trial, in all likelihood, the significant other or spouse is present. Oftentimes, applicants, injured workers simply do not want to enter into an agreement without their spouse or significant other's approval. Well, in this situation, you've got the applicant's attorney, you've got the applicant, you've got the spouse available. There may be no time like the present to enter into settlement negotiations. Do have a fun story about spouse being available at one trial. We had, it was a standard issue back case, and we didn't have much. We did have sub rosa, this gentleman going to a school and picking up his granddaughter and taking her to different places every day. But beyond that, we've really had nothing other than if we could demonstrate that he drove, which was really no big deal. That wasn't that wasn't being contested. Just the day of trial, we revealed the film, and the judge indicated that we needed to show that to applicant's counsel and applicant before we proceeded any further. Applicant's counsel did review the film, confirmed that that wasn't his granddaughter, and given the fact that the applicant's wife was in the courtroom, they pretty much did not want the film to be reviewed at trial. So settlement at trial was very much in the offing. So we got the settlement negotiations, and at that point we can craft the settlement and get it approved, because I said we've got the applicant there, we've got the applicant's significant other there, we've got the applicant's attorney, and of course we've got the judge sitting there ready to get this thing off of his or her desk. What if applicant's counsel or applicant are holding out for an unacceptable amount at the time of the MSC? Set the darn thing for trial. Folks are often shy about doing that. They feel like they've painted themselves into a corner and don't know what to do. Call their bluff. Call their bluff, and remember, every additional hour that applicant's counsel puts into this case is going to diminish the overall value of the case to them. I'm sure if they're going to be working for less per hour every time this case continues. And there's always a strong possibility that the thing is going to continue. Is applicant or applicant's counsel getting cold feet? Would either or both of them rather see the kid's recital than prepare for trial that weekend? As I said, applicant's attorney's fee is decreasing if they have to prepare for trial, go to the WCAB, wait around, get a kick to another date, et cetera, et cetera. So financially, we have an advantage there too. So yep, setting it for trial is always a great thing. What else? The trial itself, before, absolutely, before, we've just discussed that. During, certainly. There will be times that, well, I had a trial a while back in Los Angeles. Things seemed to be going swimmingly for me, and the judge turned to me and said, Mr. Barthel, does the defense remain ready to settle this matter? Well, I knew that there were some shortcomings to the trial, to our evidence. We hadn't quite gotten to that point. So I said, absolutely, yes, sir. Even though we were in the middle of the trial, we settled that thing, and my client and I were very much happy campers. What about after the trial? You've gone through all the testimony, all the submission of records, et cetera, et cetera. Is settlement after the deposition an opportunity? Absolutely. In fact, sometimes the parties would be even more interested in settling after that, because while nobody is certain of the judge's decision yet, the problems in the cases of both sides have probably been highlighted by the judge, who of course has every interest in highlighting those problems with those shortcomings for each of the parties' case, because the judge will, as always, even after trial, want to encourage settlement. PD advances. All right. Unless the applicant is returned to work or they to their job or returned to a different position, PD is payable and if PD exists. But what about this situation? Dear adjuster, I know I've been an aggressive pain in your neck. I know my client's been an aggressive pain in your neck, but my client wants a PD advance. They get some really important expenses, you know. And my client understands that this will be deducted from his award. Loving kisses, applicant's counsel. Well, is this time for you to write a check? I hope you're all shaking your head. Absolutely no, we're not going to pay for benefits that aren't already due and owing. Why? Well, now again, it's time to think about settlement. They've just tipped their hand. We don't know what those expenses are, but we know they've got expense problems, whether it's paying for the rent, paying for the car, paying for the lights, getting food in the house, whatever it is. We have no idea what it is, what the reason is that they need that money, but obviously they need the money, and clearly there's an opportunity for settlement here. You say, if you go ahead, you definitely want to say no. If you pay out some, most, or all the permanent disability, what's going to happen later? It's going to be all the more difficult to settle. Applicant's going to want more PD and won't remember that you gave them some, most, or all of the PD previously. They're not going to agree to the lesser amount, and again, it's going to be far less likely that you're going to be able to settle down the road. So from my perspective, I can't even think of a situation where I want to pay benefits that are not due and owing. Applicants' attorneys have a vested interest in settling by via CNR. How many times we've heard my client absolutely positively won't consider a CNR, and then shortly or a ways down the road, we get a CNR, signed and approved. Why do applicants' attorneys have a vested interest in settling via CNR? I mean, I know we do, but why do they? Well, how much money do they make reviewing utilization reviews and appealing to IMRs and reviewing IMRs and fighting for expediters for treatment? They may make some, but it's really not worth their while. So settling this thing, even if it's been stipulated, reviewing the opportunity to do it by CNR is definitely something that needs to be explored. So when do we CNR? When do we stip? Well, there are lots of advantages to the CNR. I think you probably know all of them. The injured worker wants that lump sum so they can put up, do the down payment or pay the mortgage, pay off debts, and as was suggested earlier, Christmas time is coming. Oftentimes debts grow even larger while they're on disability, making that lump sum seem all the more attractive. The total payout is usually bigger, no, it's always bigger than the periodic payments received from the STIP, and it's a lot easier lump sum in the bank or in some sort of worthwhile investment than are the periodic payments, which seem to just go by the wayside and be spent on this, that, or the other spurious thing or silly thing. Why else to settle this thing? Well, of course, it's by way of CNR. Obviously, it settles all the disputed issues that we may be facing. Here's one that people don't often consider now. Benefits, workers' comp benefits, are not community property, which means the spouse doesn't get their hand on the injured worker's workers' comp benefits. That is, unless commingling occurs. Applicants' workers' comp money gets commingled or mingled in with the community property, that is the property belonging to applicant and his or her spouse. So it's a lot easier to avoid that commingling when they get one big lump sum of $20,000, $30,000, $40,000, $50,000 than with these periodic payments every 2 weeks, which invariably probably just go into the checking account that's in both of their names, or goes to pay off regular debts via cash. And of course, if the applicant doesn't want to go back to work or can't go back to work, usually doesn't want to, that lump sum can tide them over as they're going through retraining and interviewing. Now with voc rehab pretty much completely dead, it's hard to figure out how they were to survive going through vocational retraining if not for the lump sum provided by way of the compromise or release. What are some of the other advantages for the employer? Obviously, a closed file is a happy file. Avoids the risk of a new and further. If we're not past the statute of limitations per se, that's something that you definitely want to get rid of. The uncertainty of future medical costs. How much is this medical going to cost in the future? We have absolutely no idea. That's a calculus that's virtually impossible to ascertain. How much was the EpiPen that you bought 3 years ago? How much is it now? I think that's a perfect example of how difficult it is to ascertain what the future medical value of this case is going to be. So as to avoid those risks, a CNR is definitely advantageous to the employer and the defense. Of course, we can get the claim reserves closed out, and you, of course, can retire. Just kidding. Obviously, the self-insured security fund deposit can also be reduced. So one of my other favorite advantages of the CNR issues such as penalties resolved without admission of fault or liability. It's nice to be able to push those to one side in the back in fine print and just make sure that everything is resolved. We used to do that a lot more with the old CNRs under the old system, but that's still possible to do by way of a CNR and impossible to hide these things or merge them in by way of the stipulation with request for award. So what can be settled by way of the compromise and release? TD, TPD, PD, pensions, future medical, out-of-pocket, penalties, interest, VR, in some circumstances not applicable anymore, obviously. You might say, well, listen, I saw the statute and said these vocational vouchers, etc., cannot be resolved. That is absolutely wrong. There's actually case law to the contrary. Same with the supplemental job displacement vouchers. Claims over which the WCAB has no jurisdiction. These can't be settled by way of CNR. For the longest time, people told me, including judges, that they couldn't be. And this is the California Supreme Court and some courts of appeal in the state of California had indicated to the contrary, that they could be settled. But we've had some new cases coming down the pike, and now it's down there. Actually, it is impossible to, with any comfort, settle a FEHA or civil or ADA claim by way of the compromise and release. At this point, if you're facing one of those situations and working in conjunction with the employer, you're going to have to either get a compromise and release that resolves both issues and have it approved by the WCJ and by a court and by a Superior Court judge, or have two separate documents, one that goes before the normal judge and one that goes through the WCJ, and simply just have the agreement to one dependent upon the approval of the other, and vice versa. Retirement issues, unknown claims, we need to identify in specificity the claims out there. As I suggested earlier, this is absolutely wrong in terms of the VR/voucher. They can be settled. The reason they're listed here is because the case law came down fairly recently, making it possible. And for those of you who are old enough to remember the Thomas finding, that's the argument here with regards to the vouchers. You have the equivalent of a Thomas finding where it is established that there is evidence that if accepted by the WCJ could cause the applicant to get a take nothing, then you get the Thomas finding or the equivalent, which can allow you to settle the voucher. There we go. There's Thomas versus Port Salet. When not to settle by way of compromise and release, well, we're still on risk. At least that's the legend. Hey, they're still working for us. We're still on risk. They claimed a low back. We settled the low back for $10,000. If we settle by way of CNR, they're going to come back next week, next month, next year with another low back injury and claim the whole thing over again. I don't know that the studies that have been run on that actually hold that up, or support that position, but nevertheless, that is certainly legend in the industry. I think perhaps it's even less likely true given our ability to access Labor Code Section 4664's apportionment. Remember that any permanent disability for which there is an award is presumptively still there at the time of a subsequent injury. That having been said, again, the industry legend is that you're still on risk. You do not CNR, you enter into a stipulation. That's for you and your supervisor and claims manager and employer to determine. When a party is unwilling to settle future medical care, for example, the applicant is concerned about the ability to pay for future medical, or you do not wish to fund the MSA, oftentimes that stipulation will work. Of course, CNR with open medical is also an option. I think we may be addressing that as well. If the MSA is too cost prohibitive, a CNR with open medical is one way to skin that cat. Or another party objects to the CNR, that may also put you in a situation where a stipend award is the only possibility. Now, settlements must be approved by the judge. I think we all know this. There's only one thing that the judge can do, though, and sometimes that fact is not shown down at the WCAB. Sometimes judges try to do more, but all they're allowed to do per the board rule is to, quote, inquire into adequacy, end quote, of the settlement. So does this mean the applicant gets every possible benefit in the record developed by the parties? I've heard some judges suggest that, but absolutely not. It just has to simply be within the range of evidence. Board rule, agreements which provide for the payment of less than full amount of compensation due or to become due, and which undertake to release the employer from all future liability will be approved, but only where it appears that a reasonable doubt exists as to the rights of the parties, or that approval is in the best interest of the parties. Sometimes the best settlement is somewhere within range of evidence, and applicant's counsel recognizes that. But sometimes the judge wants to hold up the settlement. One of the best arguments I've run across in terms of getting past the judge's concerns is to inform them this applicant does not wish to suffer through the perils of future or additional discovery. I think the judge will certainly understand that, because discovery can be quite burdensome, particularly from the applicant's perspective, having their deposition taken, sometimes multiple times, having their records subpoenaed, including those employment records of a subsequent employer, can prove very frustrating for their career, very bad for their employment record, and just a tough road to hoe. So I've never really run across a judge who's questioned the representation that the applicant doesn't want to proceed with further discovery, nor have I run across an applicant who wanted to continue with further discovery. So that's, I think, a pat way of getting around this rule, or actually of not getting around it so much as to meeting its requirements. So what does the judge use to assess adequacy? Well, the DEU rating, the information assistance officer's input, and anything else that's in the record. Now, you are, or your attorney is probably going to draft the settlement documents. The theory is that you have superior skill drafting the settlement documents, the CNR, the STIP, but be careful. Be very careful. Make sure you've crossed your T's and dotted your I's, because, well, I think I just missed that, because the drafting party, if there are any ties in the CNR, by that I mean there's anything vague. If you interpret it one way, the applicant wins. You interpret the other way, the defense wins. If there's any vagaries like that, and you were the one who drafted the document, it's going to be decided against you. That is one reason that it's sometimes advantageous to have applicant's counsel draft the CNR. That's not a good enough reason from my perspective, but it is one argument in favor of that. Obviously, we also have to provide the judge with the supporting documents for the settlement and explain the basis for the settlement. Of course, the judge can simply approve the settlement. Hopefully, he or she does so, or suspend and make inquiries regarding the basis of the settlement, or more often than not, ask for some missing documents, set the hearing on adequacy, or disapprove the settlement. The judge cannot make unilateral changes to the settlement document. I've seen judges try to do that. That is not kosher. They cannot do that. Back to the hearing on adequacy. Please, please, please have somebody down at the board for you, or a hearing rep or an attorney, and please, please, please make sure that the applicant is there, so that you can get the explanation for the judge straight, so that when the judge asks to see the applicant is fully educated as to why they don't want to proceed, why they want to settle, why they need the money, what have you, and so they know what to tell the judge. And I'm talking about making up stories, but simply explaining to the applicant the truth of the matter and how things are going to proceed, and why the settlement is to their advantage. The form, obviously we have the form, special forms for CNR or stipulations for the request for award. We're not going to go over them today. I strike that. We're not going to go over the death and dependency claim, nor the third-party CNR. Characteristics of the STIP with request for award: admitting the injury, medical care typically left open, all payments and periods and rates are specified, and however, it can be reopened within 5 years for the date of injury for new and further. And you can bet if applicant is represented, applicant's counsel has this thing diaried for a week or two prior to the 5 years running and is going to petition for new and further. When you're filling out the documents, pay special attention to the description of the injured body parts. With the CNR, you want to be expansive. With stipulation, you want to be as narrow as possible because you're going to be on the hook for treatment of any and all body parts listed on the stipulation. So again, construe it as narrowly as possible. Instead of, use foot instead of lower extremity. Use low back instead of back or spine. There's case law on point. In one case, there was a stipulation to internal injuries that had nothing to do whatsoever by fibromyalgia, but it was determined that fibromyalgia was considered something internal. Ergo, the defense was stuck after stipulating this thing with a new and further, including fibromyalgia, or strike that for treatment for the fibromyalgia. Fibro, easy for me to say. The language in the box at the bottom of page 5 will control, not the body part codes listed in the case information. That having been said, make sure that they agree with one another. Can you limit future medical treatment recommended to medical treatment recommended by the AME or QME? No, in Northern California has been my experience. Maybe in Southern California. There's definitely some places and some judges that will allow you to do it. We know that because there's case law on point, but you've got to be careful what you wish for. And let's take a look at this case, the Bertrand case. The board, in this situation, there was a stipulation with request for award, and the stipulation said that future medical disputes were going to be decided by the AME. Okay, that's kind of the way we used to do it, by the AME, by the PTP, by the QME, what have you. However, now we have UR-IMR. It was determined that in this particular case, with this particular stipulation, the parties were stuck using the AME for future medical treatment disputes, and the UR-IMR process had been waived. That's a lot to wave goodbye to. So again, be very careful how you try to limit future medical treatment in a settlement document. We referred earlier to CNR with open medical. Applicant wants, or you want a CNR. Applicant refuses to give up their future medical. They always want their future medical. The typical answer is a stipulation, but the alternative is a CNR with future medical open. Potential upsides to the employee: they retain their future medical, obviously. They get a lump sum. They get more money than a normal stipulation to buy out the other issues, the new and further, etc. And you get to avoid reopenings for new and further. You get to avoid any potential additional temporary disability and permanent disability, and or the addition of more body parts. Employer downside: this is going to be much more difficult to settle this thing by way of compromise and release, because a lot of the extra money that would go into settling the case has gone bye-bye because you included it in the original CNR. That having been said, I don't give up all hope in cases where we have a CNR with open medical, because I'm finding that people or applicants thereafter go through the UR-IMR process, find it very, very frustrating, and suddenly they find their open future medical to be less attractive than they thought it was going to be. CNR with open medical: how do we create this? The parameters are limited only by your imagination. The employer can provide the employee with a future medical for a specified body part until a specific date, for example. Draft very carefully, as I suggested earlier. The CNR must recite that future injuries occurring while receiving medical treatment are settled by way of the compromise and release. Sort of a medical version to a Rogers finding that you old dogs remember so very well. And by the way, that was an en banc decision, so that's case law that needs to be followed. P3, party with the pro pers, not Now, sometimes a pro per is wonderful, and you can deal with a pro per, and sometimes you'd really like to just be dealing with an applicant's attorney. Do they have to have an applicant's attorney? Well, obviously not. They're in propria persona. They're in one's own person. That's Latin for. What do they say about an attorney who has himself as a client? Yeah, not the sharpest tool in the shed. And there you have yours truly. How do you become a PP? Well, you stay on rep through the entire process, or you fire your attorney. You are fired. I wonder who that is. Remember, if applicant's counsel has been fired, there's invariably going to be, they're going to be claiming a fee for services rendered. There will invariably be a lien for them and for any and all additional attorneys who applicant has had and fired. So remember that you not to lose sight of that lien when you're in position to settle the case in chief. So despite the fact that they don't need to be represented, they can also gain representation at any time through the trial. However, if they've already gotten a medical legal pursuant to 4062.1, they don't get an additional medical under 4062.1E just by hiring a new attorney. So applicants really need to be careful out there. I know that we believe that judges do everything in their power to protect the applicant, and they do, but nevertheless the applicant does proceed in an unrepresented capacity at their own peril. Just ask the judge or the INA officer who suggests exploring applicant attorney options. I've had situations where the applicant has been pro per and has been made clear in front of the judge that they're not the most pleasant person in the world to deal with. I've seen in that situation the judge look at the applicant's attorney in the back and say, hey, can you handle this case? Applicant's counsel, having listened to the case, has no interest whatsoever in handling it. So the judge is asked if they might go down the hallway and get somebody who is less aware of the perils of dealing with this applicant if they'll handle the case. And in short order, they will get an attorney for them. Oh, the employer need not provide the pro per of notices and information beyond that which is normally required. In short, the notices that you have to provide them when they're represented are exactly the same notices and information that you have to provide them when they are pro per. I know that there's an impression that applicants never lose, but that's actually faulty. We've got case law to the contrary. In this Duarte case, for example, the pro per failed to file a timely petition for reconsideration. And when the defense brought up the statute of limitations, she said, well, hey, the employer should have advised me of my right to reopen within 5 years. Well, remember, which is what we just said, that the pro per gets no additional notices or warnings than they would get if they were represented. That's absolute case, and it was found that the employer could successfully assert the statute of limitations in that particular case. Now, interestingly, obviously the applicant need not be an attorney. I'm sure you've dealt with many pro pers who are not. But they may perform services, all the services in court in any matter throughout its various stages, so long as they're within conformity to the rules of procedure, from the beginning, from the filing of the claim form to the end of the appeals process through to the California Supreme Court. In fact, theoretically, you could file to the U.S. Supreme Court, although the DCA and Supreme Court, but highly unlikely. The applicant can file an application and request a medical evaluation to resolve a disputed issue. What else can they do? They can represent themselves at the conference and represent themselves at the trial. Well, the cross-examination is very interesting. Isn't it true that, well, yes, it is true, coming from the same person. The judge will help in that testimony and elicit the questions that the judge is interested in learning more about. The applicant can conduct discovery, although what are the chances that they're going to understand the ability to take take witnesses' depositions or subpoena records? And they can cross-ex or produce witnesses at trial. What else can they do? They can screw up their own case, and that oftentimes is the situation. Adams versus WCAB, for example, we got a pro per who the judge aided in terms of obtaining documents from the employer. He permitted the applicant to produce the witnesses, to cross-sex the witnesses, testify, but applicant didn't realize that he had to prove employment. Obviously, that's the most basic thing you can prove when you're dealing with a workers' compensation case. Failed to prove employment, ergo, lost this thing. Even though they claimed due process violation, there certainly was not, because Adams had every opportunity to prove employment. They just failed to understand what the factors were that they had to prove to hold up their case, to win their case. They filed a recon, went to the DCA, and lost all the way through there. What can't the PP do? We've already talked about a few things. Can't go to an AME, can't avoid the panel process if a medical legal is required, requested by either party, and can't go to arbitration. Labor Code Section 45270 makes clear this part shall not apply, this part being the arbitration portion of the Labor Code, shall not apply in cases where an injured employer dependent is involved unless the employer dependent is represented by the attorney. Also, a pro per cannot be represented by a non-attorney. So an applicant can be represented by an attorney, an applicant pro per can be represented, or can represent themselves, but a pro per cannot be represented by a hearing rep or other non-attorney. Settling with a pro per, it can be a tough putt, more difficult than when applicant's attorney is involved, because the judge is going to be more, if the judge knows applicant's counsel, they've got a good reputation, the tough combatant, and know that they represent their client's interests very well, then the judge is going to be less likely to take a look at the documents very closely. They know the job has been done. With a pro per, they're always going to be worried that the pro per, his rights have been in some way trampled or violated, so they're going to look at this thing much more closely. They're going to be extra vigilant. And they're also going to make sure that the policy and procedural manual has been followed to a T. Remember, when you're settling with a pro per, the settlement documents need to be submitted along with all the relevant medical reports, the basis for the settlement, and the more detailed the basis, the better. Ratings of all the P&S reports, and that can come from the DEU, a private rater, and or the adjuster, him or herself. By the way, if there's multiple body parts or non-scheduled ratings, those of you who remember the old 1997 schedule and the non-scheduled ratings, we don't have that so much with the 2005 and the AMA guides. But if there are non-scheduled ratings in these old cases, they must use the DEU. Finally, we have to have the basis and calculation of the AWW if they're anything less than the maximum. We submit these documents along with all the notices that were sent to the applicant regarding the settlement, regarding the QME process, most recent printout of benefits paid, what's something that for some reason people slip up on providing, and proof of service of everything on everyone, including the lien claimants and the pro per. Now, this is interesting. Old school, this is no longer the rule, but formally, if a settlement was walked through, the pro per must be present when the settlement judge, unless already reviewed by the INA officer with the pro per. I don't care if that's the old school. Do this anyway. This is going to be the one way that you can dramatically increase your odds of getting this settlement through. So have somebody there, a hearing rep, an attorney, adjuster, whomever, who can hold the applicant's hand, get them through with the INA officer, get them up to the judge to explain why this settlement they believe is fair and how they want to resolve this case by way of the settlement documents. This is, again, going to dramatically increase the chances of getting this thing settled. Stipulations, CNRs and stipulations with pro pers filed with the WCAB must go to the INA officer who's going to review the settlement, contact the parties if needed, and coordinate within other units of the DWC. And coordinate, make sure that the applicant understands the agreement, and make recommendations to the applicant, the defense, and to the judge. Make the DEU, make the information assistance officer and EDD your friend. These are obviously the judges as well. But the INA officer, you want them to know you, to know your reputation, to know that you're a fair individual, so that it will help expedite resolution and getting the settlement through the INA officer and to the judge for approval. Now, dealing with a pro-per, everybody's considered equal, but of course pro-pers are more equal than others. They're allegedly held to the same standards of procedure, but that's not necessarily true. This is made all the more true because procedures are, as you know, are very, very informal. And the WCAB primarily views their job as making sure things are fair. They're going to make inquiry in the manner through oral testimony records, which is the best calculated to ascertain substantial rights of the parties and carry out justly the spirit. What does this 5708 mean? It means that the judges are going to be more lenient on the applicants and try to help them along to the extent possible. Pleading requirements are frequently relaxed for them. They're not going to require them to necessarily cross their T's or dot their I's. We do not believe, said the court, we do not believe that awkwardness in the allegation should constrict a worker's right to compensation. Applicants are entitled to adjudication upon the substance rather than formality of the statement. So we are not going to do a form over substance kind of thing. How lenient can they be? Well, for example, there was a case a while back in which the applicant failed to submit evidence at or before the MSC. We submitted it after the MSC. The issue was, are you kidding? It's after the MSC. Discovery has been cut off. What was the holding? Doesn't matter. The applicant misunderstood the trial process. Now, I don't understand this case. The applicant having a fundamental misunderstanding of the trial process seems highly likely. Number one, fully expect that the judge explained to him or her at the MSC that that was the end of discovery. And two, isn't that what applicants' attorneys are for? That's why applicant was probably well advised to get an attorney. This is actually a fairly recent case. All right. All right, Medicare. We're going to talk about Medicare for about 3 seconds. Old school, who cares, right? We'd settle for a discounted amount in the CNR with the understanding that applicant really needed future medical care. They could always go to Uncle Sam. No more. I know that you're fully aware of the authority for Medicare, the National Federal Health Insurance Program, making available medical care to U.S. citizens. U.S. citizens. Note that's U.S. citizens. As an MSA required for somebody who is not a U.S. citizen, whether illegal or not? No, absolutely not. So, do you feel lucky, punk? Well, do you? Go ahead and live without your MSA. Fun fact, neither Medicare Secondary Payment Acts nor federal regulations require MSAs. That does not mean you should be flying naked without one. It's all about the memos. There's virtually no case law. I mean, you can count the number of cases regarding MSAs probably on one hand. And if not, on your two hands and your feet, you've got it covered. All the information interpreting things are found in the CMS memos, which can be found at this website. Basically, what's required is that all workers' compensation settlements adequately consider Medicare's interest. What's a secondary payer? Medicare through CMS is not primarily responsible for work-related medical care. They only pay in certain situations. They ignore workers' compensation settlements if their interests aren't quote-unquote considered and considered adequately. And what are their options? Let's say you enter into a CNR. You have not gotten a plan, an MSA. You have not adequately considered CMS's or protected CMS's interest. Well, CMS can demand reimbursement for any medical care they provide or withhold that medical care. Now, what about a hold harmless clause? Applicant agrees to hold the defense harmless, or the defense agrees to hold the applicant harmless if CMS comes back around and wanting money. No, absolutely not, because all parties are potentially liable. Applicant's counsel, the defense attorney, et cetera, et cetera. Hold harmless clauses are absolutely worthless. The solution, as I suggested earlier, are MSAs. Why am I talking about MSAs right now? Well, because it's it's all about the timing to help expedite the resolution of the case. Obviously, the objective of the MSA is to preserve Medicare status as a secondary payer, not a primary payer. In short, they're supposed to only pay medical bills when there is no other payer, aka the employer or insurance carrier, available and responsible to make those payments. Let's skip out that real quick. We're going to skip that. I just want to get this up because we're almost out of time. So you're ready to CNR. You have some medical care projected, but not likely too bad. It doesn't matter whether they're Class 1 or Class 2 settling future medical care. We still have to reasonably anticipate how much medical care there's going to be and provide a basis for that conclusion. Now, how much money is required for Medicare protection? We don't know, but the rule of thumb is the larger the settlement, the more likely medical care is that Medicare is going to require more. The only question is, how quickly are they going to demand, or how quickly can you get this thing through? And here's exactly what I want to go. Submission and approval. The allocation is submitted for approval to the federal government. A case number is assigned. A receipt is received, approximately 45 days before you get the receipt. Allocation documents reviewed include the total allocation, the itemized workup sheet, et cetera, et cetera, et cetera, and last 2 years of medical reports. If there's incomplete information or they need more information, CMS goes to the submitting party. If the medication is no longer prescribed, they want a letter signed by the employee confirming that. They can do what? They can approve the request. They can ask for clarification from a doctor. They can find the allocation inadequate. If inadequate, they can provide a conditional approval. What's the point with this? It's going to slow dramatically. You're going to be waiting on the answer potentially for a very, very long time. It's actually, the time is shortened from many, many, many months to 2 to 4 months. Take away from that, start the set-aside process as early as humanly possible. Submit to CMS before the settlement is made. If you've got the requisite documents, the requisite medical reports, you can do that. Negotiate settlements with the MSA in hand. That can make all the difference in the world and avoid delays that might otherwise undercut your settlement efforts. All right, we're going to stop there. I'm looking forward to talking with you all next month. And hang on one second because I'm going to have Tammy drop a few notes to you.
Once again, there's Don's contact information there on the screen if you need to contact him. I know there were several questions submitted today, and unfortunately we're out of time and don't have time to answer them, but Don will email you back individually in the next 24 hours or so and get your responses to your questions. Thank you all for attending today, and have a wonderful afternoon.